Employment contracts are documents that set out the terms and conditions of an employer-employee relationship. These contracts must adhere to applicable employment standards legislation. In Ontario, we refer to the Employment Standards Act, also known as the ESA. The ESA sets out a variety of minimum employment rules, and employers cannot contract out of the ESA and cannot provide terms less favorable than what the ESA prescribes. However, employers are able to provide employment terms that are better than the ESA. There are three key types of employment contracts: indefinite term contracts, fixed-term contracts, and project-based contracts. As the name suggests, indefinite term contracts are a form of employment contract that do not set out an end date. An employee is employed indefinitely for these kinds of contracts. If an employer terminates the employment relationship, the employee may be entitled to wrongful dismissal damages. Fixed-term contracts are a form of work agreement that terminate the employer-employee relationship on a predetermined date. If the term specifying the end date of the contract is valid and enforceable, the contract can be terminated without cause, and the worker will not be entitled to a notice of termination or severance pay, as the termination was agreed upon at the beginning of the contractual relationship. However, if a worker is terminated without cause prior to their specified end date, then they may be entitled to damages equivalent to the remainder of the fixed term. Project-based contracts are similar to fixed-term contracts, as they are based on a finite timeline. However, in the case of a project-based contract, the end date is based on when the specified project is completed. Employment contracts as a whole should contain a variety of terms, such as wages, job responsibilities, and hours. Terms within the contract cannot be worse than what is provided for in the ESA. It's important to look out for any clauses or terms that limit your rights as an employee, such as layoffs and probationary periods. Layoffs and probationary periods must be agreed to in the employment contract. So generally, unless your contract states that your employment is subject to a probationary period of a maximum of 90 days, your employer cannot terminate you without at least paying severance pay. Termination clauses are another type of clause that are written with the intention of limiting the employer's liability in providing termination and severance pay. When reviewing employment contracts, it's important to keep the following in mind. Negotiate terms where appropriate. Do not rush to sign the employment contract and consider seeking legal advice. And familiarize yourself with your rights under the ESA.